Welcome back to Clause for Concern, Notwithstanding Canada's Charter. In this episode, we look to the Government of Ontario's recent use of the Notwithstanding Clause. If you haven't already checked out Episode 1, where we start with the basics, we recommend listening to it before this episode, which looks more closely at the clause in action. Today's story begins in 2018, when Ontario Premier Doug Ford tried to use the clause for the first time in the province's history to reduce the number of seats on Toronto's City Council during a municipal election. After the Ontario Superior Court found that the council's shrinking bill, quote, clearly crossed the line, end quote, Ford vowed to use the notwithstanding clause to prevent the law from being struck down. A frantic week of political activity followed, seeing NDP members of the provincial parliament tossed from the legislature to public gallery observers arrested and an all-night legislative sitting. Though the bill ended up passing without the need to invoke Section 33, the battle over Toronto City Council marked the beginning of a new era in Ontario, with the government going on to invoke the clause twice in 2021 and 2022. The 2021 invocation, which further restricted third-party political advertising in Ontario, was recently challenged before the Supreme Court of Canada, with a final decision pending at time of recording. While this litigation was ongoing, the Ford government then struck again after 55,000 teachers and school support staff voted to strike after months of negotiations. In response, Ford passed a law to force teachers back to work, shielding the law with the notwithstanding clause. Trying to strip teachers of the ability to strike caused uproar from all sides of the political spectrum, leading the government to ultimately back down and repeal the law. All three Ontario cases involve a sort of call and response between the government and the electorate, with the people using both protest and the courts as tools for scrutinizing the government's use of Section 33. In this episode, we explore these dynamics with Marion Sandilands, a part-time professor at the University of Ottawa's Faculty of Law and partner at Conway Litigation, and with Kris Kinsinger, a lawyer with SV Law and former director of the Runnymede Society. Hello, Marion. Welcome to the podcast.
Hi, great to be here.
So, in 2018, Ontario starts to toy with the use of the notwithstanding clause. And it does so leading up to the City of Toronto municipal election. Can you tell us what happened there?
So this was in 2018. The Ford government passed legislation to basically cut the size of Toronto City Council in half. But what was kind of shocking about this was that they did it right in the middle of the municipal election campaign. So that threw the campaign into disarray. And the City of Toronto challenged that legislation on the basis that it violated freedom of expression, Section 2B. And it won that challenge at first instance. And so Ontario didn't want to give up. They appealed that decision. And at the same time, the legislature tabled legislation invoking the notwithstanding clause for the legislation. So you had, on the one hand, an appeal going, and on the other hand, tabling legislation to invoke the notwithstanding clause. Now, on the appeal side, Ontario ended up winning their appeal. So the legislation was never actually adopted because it wasn't needed. So when you count actual invocations of Section 33, a lot of people don't actually count this one because the legislature never actually adopted the legislation invoking Section 33. But I usually count this one because it was a big first in Ontario, and the specter of using the clause is a big deal, and it was a big deal at the time.
When the notwithstanding clause was floated as a shield for the law by Ford's government, do you think people in Ontario had a clear sense of what that meant?
So I'm not an expert in public opinion, but I do recall there was a lot of discussion in the media at the time. It was a big deal, at least sort of in the media. And there was a group of more than 80 law professors that signed an open letter urging the government not to go through with invoking Section 33. And that's pretty unusual. And at the time, though, I'm not sure the public would have had much understanding of what Section 33 is because it had never been used in Ontario. Some folks of a certain age might remember it being used like in Quebec in the 1980s. But other than that, it hadn't been discussed in the media or in politics in Ontario for probably decades. So I would guess that public awareness of Section 33 at that time would have been quite low. I think it's higher now because we're seeing it used more and more often.
So we know that it doesn't end up getting invoked, but it's already clear that the Ford government is open to it. And then in 2021, the story continues when the Ford government passes another piece of legislation about political advertising. So how does a seemingly boring bill about political advertising turn to play such an important role in our story?
Yeah, I mean, nothing's boring to a law nerd like me, but yeah, it's a strange place to find this kind of controversy. So I'll put it in context. In Canada, there are spending restrictions on political parties and on third parties. So those are organizations like civil society organizations or lobby groups. There's restrictions on what they can spend during an election period, but also in the period leading up to the election, so the pre-election period. Long story short, the government changed the law to add more restrictions to what third parties could spend in the pre-election period. So it extended the pre-election period from 6 months to a year. So just added more restrictions to third parties. Now, any election spending limits in Canada are subject to a challenge under freedom of expression, Section 2B of the Charter. They're often challenged, and that's what happened here. So some civil society groups challenged the law under Section 2B, and it was actually a group of unions, and they won at first instance. So a Superior Court judge found that the new law unjustifiably infringed freedom of expression. But instead of appealing that decision, which is what governments normally do when they lose a constitutional challenge, the Ford government instead immediately reenacted the legislation with the notwithstanding clause in it. It's kind of a shortcut to keep the legislation in effect, and it ended that constitutional challenge.
So when they reenacted the law using the notwithstanding clause, what were the reactions?
So in my recollection, the reactions were less strong and less drastic than what we saw with the City of Toronto invocation or threatened invocation. So some, law folks spoke up and said, hey, not cool. But in my recollection, this issue didn't have nearly the same profile as the City of Toronto instance. And I think that's a trend. I think the more we see Section 33 used, the less of a big deal it is each time.
So after the Ford government swoops in with the notwithstanding clause, the law gets challenged again. And the challenge eventually works its way up to the Ontario Court of Appeal. How did the Court of Appeal deal with the law? And more generally, how was it possible to challenge the law despite the invocation of Section 33?
Okay, so here's where the story gets even more convoluted. So on the second go round, the same plaintiffs came back to court and said, we're challenging this law on two grounds now. First, that the legislature improperly invoked Section 33, and therefore, it still unjustifiably infringes expression. And the second ground, which was a new ground, which was Section 3 of the Charter, which are the democratic rights. So fun fact, Section 33 doesn't apply to all charter rights. It only applies to Section 2 and Section 7 through 15. So that leaves out the democratic rights, mobility rights, and language rights. Those rights cannot be overridden by Section 33. So when the legislature invokes Section 33, the democratic rights are still on the table. So there was a new argument crafted to say that this legislation infringes Section 3 of the Charter. The argument was basically that we have these democratic rights, the right to vote in an election, and in order to meaningfully exercise these democratic rights, voters need to have enough information and that restrictions on third-party spending, well, they restrict that informational component, and therefore that they infringe Section 3 of the Charter. Now, at the Superior Court, the plaintiffs lost on all of their arguments. At the Ontario Court of Appeal, the court barely wanted to talk about the invocation of Section 33. They simply said, no, we're bound by the Ford decision and we can't review the use of Section 33. But the court went on to do what seems like a very novel thing with Section 3. So they found that the law does infringe Section 3 of the Charter. So in the result, the court struck down the legislation on the basis of Section 3. It's kind of a backdoor. And I find this interesting because the courts here, they didn't want to take on the elephant in the room, Section 33, but they were reaching the same result by broadening a right that isn't subject to Section 33.
The case we're talking about, which is called Working Families, was recently heard by the Supreme Court, and now we wait for a result. Do you have any predictions about how the court will decide this issue?
So actually, I represented one of the interveners before the Supreme Court, so I got a front row seat at the hearing. What's really interesting about the Supreme Court level was that Section 33 got dropped off the appeal because the Ontario Court of Appeal had found, there's nothing we can review here about Section 33. That finding was not appealed. So the only issue before the Supreme Court was whether the legislation violated Section 3. And my sense from the hearing was that the Supreme Court really didn't want to talk about Section 33 at all. Again, it's the elephant in the room. But what I found also interesting was there's all kinds of confusion at the hearing about the relationship between Section 3 and Section 2B. So the original ground that it was challenged on. Are these the same thing? Are they different? How are they different? And what happens to Section 1 justification if you find a Section 3 violation? So all of these confusing charter questions, to me, they're all a direct result of the fact that Section 33 was invoked here. Nobody was talking about Section 3 at all until Section 33 was invoked. So my takeaway is kind of you ignore the elephant at your own peril.
Okay, let's move on to 2022. When Premier Ford again tries to use the notwithstanding clause, this time in dispute with teachers. Can you walk us through what led to the Ontario government's use of Section 33 in the Keeping Students in Class Act?
So this was a labor dispute. I think it was education support workers. They were at an impasse in the negotiations of their collective agreement, and they were about to go on strike. And the government enacted back to work legislation and preemptively invoked Section 33, ostensibly to shield the law from any challenges based on freedom of association. Unlike with the Toronto City Council instance and the election spending instance, with the strike legislation, there was a huge and immediate public backlash. Now, remember, these are labor unions and they're ready to go on strike. So there's a very loud and very organized cry at this moment against the use of Section 33 in this back to work legislation. And there were even threats of a general strike. And there were denunciations at the political levels all the way up to the Prime Minister. And interestingly, a few days later, the legislature repealed the legislation and the strike was eventually resolved through the usual process of negotiations. So in some sense, we kind of see the democratic function of Section 33 working here. We have a public outcry and the legislature responding to that. And also, interestingly, Ontario hasn't invoked Section 33 since this time.
Why do you think there was such effective public mobilization against the use of Section 33 in this case, especially in comparison to other uses that haven't been withdrawn, like Quebec's Bill 21?
That's a great question. I think, as I said, these were, labor unions who were already organized and poised. They had natural networks of other unions and other ways to kind of mobilize quickly and create a large public outcry. I think that made a huge difference. I think the public reacted differently from what the government was expecting, and the government responded to that.
Okay, so my next few questions are super law nerdy, but really, if you've made it this far, congrats. You're a law nerd too. So my first nerdy question is, if it's okay for a government to use the notwithstanding clause before a court has ruled that the law is unconstitutional?
So I think I'm going to split this into two questions. As a law nerd, there's question one, is it legal? And question two, whether or not it's legal, is it okay? So the first question, is it legal? Yes. This question was decided in the 1988 case of Ford. The Supreme Court said that, you know what, so long as the legislature uses the right words, the legislature can preemptively use the clause, and the court cannot scrutinize the legislature's reasons for using the clause. And unless the Supreme Court changes or nuances this in the future, that's the law right now. So yes, they can. Now, the second question is it okay? That's trickier. Some people say it's never okay to use the clause preemptively. Some people say it's always okay. My take is, well, why not wait to see what the court actually says before going with the nuclear option of Section 33? So as a technical matter, whenever legislation is enacted, it will go into effect. There's never a legal need to use Section 33 as a first resort. So when you see it used as a first resort, I think it's being done for other reasons. And I think what we're seeing these days with the preemptive use of Section 33 is Section 33 being used to polarize and divide. It's sort of taking a hot political potato, whether that might be religious symbols in Quebec or a strike in Ontario or trans kids in Saskatchewan, and lighting that issue on fire. It's an elected leader saying, I have this power, and because I have it, I will use it. You can't tell me not to. And I don't think that's healthy. I think governments have plenty of tools at their disposal to get their policies through. And when they use Section 33 preemptively like this, I think there's something else going on.
So if the government can use the notwithstanding clause preemptively, should a court be able to at least recognize the law's inconsistency with the charter? What would that mean?
So this is a theory that's been put out there, and it's actually being tested in the courts right now. The idea is that if Section 33 is used preemptively, maybe the court can't strike down the law. Section 33 prevents that. But maybe a court can still rule on whether the law actually violates the charter unjustifiably. So does it actually violate X or Y charter right? So for example, in the case of Bill 21, that's a preemptive invocation of Section 33. The theory goes, well, a court can't strike it down, but maybe a court can say, I declare that this law violates Section 2A and Section 15 of the Charter. So the proponents of this theory argue that even if that declaration doesn't have immediate effect, it doesn't change anything in the law, it does provide important information to electors. Because don't forget, Section 33 has a 5-year sunset period. So at the end of that 5-year sunset period, the legislature has to decide whether it's going to reenact it. And a court's ruling on whether it's unconstitutional might inform public opinion on whether it's a good idea to renew the clause. And of course, if the clause isn't renewed after 5 years, it automatically expires. And then with that declaration in place, the law kind of automatically becomes unconstitutional. So that would save time having to challenge it after the 5 years.
So the government using the clause in the CUPE case feels like a preemptive use of Section 33. But some people have suggested that it's actually better viewed as a response to the Supreme Court reading the right to strike into the charter back in 2015. What do you think about this argument?
So a lot of invocations of Section 33 do have some kind of pedigree or history like this, but this isn't the first labor disruption since 2015. There have been lots of labor disputes and even back-to-work legislation passed since the right to strike was recognized in 2015. And none of them invoked Section 33. So don't forget, we have Section 1 in the Charter. So a law can infringe the right to strike so long as its infringement is demonstrably justifiable in a free and democratic society. So what that means is the government has to go in front of a court and explain why a violation of the right to strike is demonstrably justifiable. That's how the charter works. And that's how, for example, all the pandemic restrictions worked. Using Section 33 like this It just means that the government doesn't want to explain to a court why a rights infringement is demonstrably justifiable in a free and democratic society. And I think we should ask ourselves, why would that be?
All three of the situations we discussed were in the news across Canada and may have emboldened other provinces to start using the clause after decades of hesitancy. Do you think this signals a shift in our political or legal culture?
Big time. I think provinces are definitely looking to one another. We see a lot of interplay between Saskatchewan, Ontario, and Quebec here. There's patterns. I think this is a huge signaling a huge shift in political culture. Some people would say, well, no, we're just seeing a natural rebalancing of power between legislatures and courts. And there is something to this. But I think we also need to ask ourselves, okay, but why now? And who benefits? I think we need to look at these issues not in isolation, but as a trend, and as a trend in the context of what's happening in liberal democracies worldwide. What's the rhetoric around the use of Section 33? Who benefits from that rhetoric? Like, who benefits from a weakening of entrenched fundamental rights? That's the culture shift I think we need to be thinking about.
Have the court's decisions had an influence on the way the public is thinking and learning about the notwithstanding clause?
There have been a few lower court decisions in Quebec and Saskatchewan that comment on the use of Section 33. So, for example, in Quebec, in Bill 21, the trial judge, he ruled that, okay, his hands were tied on Section 33. He couldn't scrutinize the use of it. He couldn't strike down the law that was protected by Section 33. But he went on for several paragraphs to comment on how broad and sweeping and unprecedented this was. And I think that was trying to send a message to the public and to the legislature about how serious this was. But then on appeal, the Quebec Court of Appeal gave Section 33 its blessing. So that sends a message too. So I think the Supreme Court is going to rule on these issues within the next few years. And when it does, I think that decision is going to hopefully leave a huge mark on the saga and hopefully send a message to the public.
As a final question, should Canadians be concerned about the notwithstanding clause? And if so, how concerned should they be?
Emphatically, I would say very concerned. I think the public really needs to engage on this topic. We have a Charter of Rights. It's a huge, important check on government power. It's a central feature now of our constitutional democracy. And yet it has this untested kind of escape valve or Achilles heel. And how, I think we should wonder, how far could the government take this? And as the law currently stands, the legislature can apparently override really fundamental things like the right to a fair trial or the right to be free from arbitrary arrest. There's no obvious legal check to that power right now. And, people would say, well, that's out of the scope of possibility. There's a lot about Canadian law and political culture that depends on our elected leaders holding to certain democratic norms and values. And Section 33 is a really important example of that. But if those norms and values aren't there, we're kind of into a legal no man's land. And so the notwithstanding clause is a great example of this, the importance of norms and values. That's the way our Constitution is structured. And it means that citizens play a huge role in making our constitutional democracy work properly. If a legislature invokes Section 33, the buck doesn't really stop with courts. It stops with the citizens. So we as citizens need to decide for ourselves each time, is a given use of Section 33 appropriate? And we need to hold our leaders accountable for that. And I think if we don't, our leaders are going to continue to use this power just because they have it. And we will continue to see it normalized. And we will continue to see this erosion of respect for fundamental rights and tacit permission for their leaders to trample those rights. And let's see where that takes us.
Well, that brings me to the end of my questions. Thank you so much for your time and expertise, Marion.
My pleasure.
Hello, Kris. Welcome to the podcast.
Hey, Saloni, happy to be here.
So, we titled this podcast A Clause for Concern. But not all scholars agree that the notwithstanding clause is something Canadians should worry about, even if it is used frequently. What value do the clause's supporters find in it?
That's a great question, Saloni. What you will hear proponents of the notwithstanding clause point to is, first of all, going back to the history of the drafting of the charter and the negotiations that led up to the passage of the charter. There's a very strong argument to be made that were it not for the inclusion of the notwithstanding clause, we would have no Charter of Rights and Freedoms. So even those who are supportive of the Charter can point to the notwithstanding clause and say this was an important part of the compromise that led to the Charter's enactment. And what the concern was at the time when the provincial premiers were negotiating with the federal government over the patriation of the Constitution and the enactment of the Charter was that the Charter would grant sweeping new authorities of judicial review to the courts. And that is, in fact, the case. And that did happen even with the inclusion of the notwithstanding clause. But there was a push to include something like the notwithstanding clause to provide, some call it a safety valve, some call it a release valve, whatever you want to call it, but some sort of mechanism that would at least preserve some legislative authority in the face of these new sweeping powers of judicial review that were being granted to the courts with the enactment of the Charter. And so the rationale here is that the notwithstanding clause serves a primarily democratic function, or at least it helps provide balance between democratically enacted legislatures, which have a constitutional role to play, and the courts, which are not democratically enacted or elected, rather, but nevertheless, they also have an important role to play. And so the idea here is that the notwithstanding clause can help to provide institutional balance between the respective authorities that both legislatures and courts wield. So I'm sure we'll get into this as well, into some of kind of the finer minutia of the defenses of Section 33. But the idea that really kind of emanates from recognizing this historical reality and recognizing this basic role that the notwithstanding clause plays in promoting this kind of institutional balance is that the notwithstanding clause is part of the Constitution. And so very often proponents, and I would agree with them on this point, when people say that the notwithstanding clause overrides the Charter, well, that's just simply not correct, because the notwithstanding clause is part of the Charter. And because were it not for the notwithstanding clause, we arguably would have gotten the Charter in the first place.
In a CBC interview during the dispute over the restructuring of Toronto City Council, Rachel Curran, a lawyer and former policy director for Prime Minister Stephen Harper, applauded the Ford government's move to use the notwithstanding clause for the first time in the province's history. She made comments on three distinct issues, sometimes brought up by supporters of the notwithstanding clause. And I want to ask about each of these issues in turn. First, Curran brought up the issue of judicial elitism. Can you explain what this is and how the notwithstanding clause potentially alleviates the tensions caused by it?
Yeah, I'd be happy to. And Rachel raises a number of good points here that many proponents of Section 33 have drawn on. What Rachel is really getting at here is kind of what I alluded to earlier, that the whole idea behind having a notwithstanding clause is that it provides balance between democratically elected legislatures. And I'm using that word, by the way, very intentionally. I'm saying legislatures and not governments, because Section 33 is a legislative tool. So the government per se, the executive branch, the premier or cabinet, or if we're talking federally, the prime minister and cabinet, cannot decide to invoke the notwithstanding clause. It has to be done by the legislature. And that's a really important point here, is that Section 33 can only be invoked by those who have been democratically elected to a provincial legislature or to the House of Commons. And so the idea here is that there may be times when you have judges acting within their authority who potentially overstep the bounds of those authority, who might issue a questionable ruling. No disrespect to the late Justice Bellababa, who issued the Ontario Superior Court ruling in Toronto and Ontario. There was certainly a fair bit of criticism that came out at the time that his decision was not consistent with past jurisprudence, that it was not consistent with established constitutional doctrine about the role that quote unquote unwritten principles can play in striking down legislation. And so really the idea here is that in those kind of cases, Section 33 can provide a bit of a check on actors within our constitutional institutions who are not subject to democratic accountability, by ensuring that those who are able to balance out those decisions with their own decisions, which may reflect a different interpretation of the law. It may not be based on a legal interpretation at all. It may be based on other policy considerations that really go beyond the scope of purely legal considerations. So I think that's really what Rachel is getting at here about kind of the offset that Section 33 can provide when judicial authority is misexercised or when it's exercised beyond its proper role.
So Kern pointed out that the legislation was invoked by a democratically elected premier and supported by a majority of citizens. Is majority support a sufficient justification for invocation of the clause? And if so, where does this leave minority voices and interests?
It's a really good question. And really what you're kind of, what we're going to get at here, I suppose, is pulling back the curtain a bit on my own views of Section 33. And really, I don't consider myself to be a proponent or an opponent of Section 33. I consider myself to be something of a Section 33 moderate. I don't look at the clause as being inherently good or inherently bad. It's a tool. It's a legislative tool. And like all legislative tools, it can be used properly or it can be used poorly. So to really kind of assess any particular invocation, I think it has to be done on a case-by-case basis. There may well be times when overwhelming democratic support does provide sufficient justification for the invocation of the notwithstanding clause. If there is this general sense, this is particularly when we're getting into maybe not a case so much as City of Toronto, but something that concerns more justice policy. If there is an overwhelming sense amongst the electorate that, say, a particular law which had been struck down by the courts was in fact just, that may provide justification for the democratically elected legislature to act on the basis of that support and to reenact the legislation with the notwithstanding clause. But there are going to be other cases where there are certain features of our Constitution, there are certain features of the Charter that are meant to provide enduring guarantees and protections for minorities. This is something that predates the Charter. The protection of minority rights is not something that arose in 1982. It's long been a feature, perhaps albeit an embedded or an implicit one, of our constitutional order. And so this is what allowed the Supreme Court in the succession reference to refer to the protection of minorities as an unwritten constitutional principle. So I do think there are cases when Section 33, even where there is a majority of people that support its invocation, can be invoked in an unjustified way. I've been quite clear on the record that my own view is that this is the case with Quebec's Bill 21, an act respecting the laicity of the state, which in my view imposes restrictions on the rights, particularly of religious minorities, in a way that is just not justified in a free and democratic society. Now, whether or not that legislation will be upheld because Section 33 has been invoked is still an open question. The Quebec Superior Court has said that the legislation is constitutional, rather. The Quebec Court of Appeal agreed. Leave to appeal to the Supreme Court has been granted. Is pending, rather. So we will see whether or not that leave is granted. And the court may have to wrestle with a lot of these issues if and when that case comes before it.
Ms. Kern finally indicated that Premier Ford may have been sending a message to the judiciary. If he was, what might that message be?
This is a really interesting part of the current conversation around Section 33. And I think it's a conversation that we are really having now at this particular point in time. Section 33, as you noted, has been invoked many times over the course of the Charter's history. There's a bit of a sense that it was never used before and all of a sudden it's being used now. That's not quite accurate. Certainly, I think it's fair to say that we are seeing it being used more frequently and more openly. And falling within that, if we look at this particular point in time, we have to ask the question of why are provincial governments reaching for the notwithstanding clause more readily, perhaps, than they have in the past? And so what the proponents of Section 33 would say, and I think many of them have raised very good points here, is that there are areas of the law where courts have potentially overstepped the bounds of their authority, where they have adopted interpretations of the Charter that are not borne out by legal doctrine, where they have waded too far into the realm of policymaking and have used the Charter to essentially dictate areas of policy, to provide a blueprint for how legislatures are to positively enact policy rather than just placing restrictions around what may be legitimate or illegitimate restrictions on rights or freedoms. So I think the idea here is that if this is a trend, if we have seen perhaps the pendulum swing too far in the direction of exercises of judicial authority to strike down legislation, that Section 33 can serve as a bit of a signaling function by the legislative branch of the state to put the judiciary on notice, essentially, that they are paying attention here and that they don't always agree with those rulings. And that may itself serve as a potentially necessary corrective function if this happens more and more. And if, in fact, these rulings are being are exceeding legitimate judicial authority, or if they are being handed down outside of the scope of established legal doctrine, then the invocation of Section 33 could arguably serve as a bit of a signaling function and help bring things back into a little bit more of an equilibrium. So I think that's the idea here. But of course, that's not to say that each and every time the legislature reaches for Section 33, that is, of course, what it's doing. To be fair to those on the other side of this debate, the critics would say sometimes that this isn't really about the pursuit of an alternative interpretation of the Constitution or seeking to balance what the courts have said with other policy concerns. The critics would say this is really just about the raw expression of institutional will, and that some governments or legislatures just may not like to have courts standing in the way of what they want to accomplish. So this is a really tricky debate, and it's really nuanced. And so, like I say, that's why very much I would see this as something that needs to be assessed very carefully and very thoughtfully on a case-by-case basis.
So in the final portion of this interview, we want to look at the preemptive use of the notwithstanding clause. There's a lot of debate over preemptive uses of Section 33, where a government invokes the clause before a court has ruled against the law. The Supreme Court has been clear that preemptive use is perfectly legal. But do you think it's an appropriate way for governments to use the clause, generally speaking?
So you're right to emphasize that just as a matter of legality, as a matter of formality, there is nothing illegal about preemptive invocation of Section 33. There are some arguments that have been raised of late, fairly novel arguments, trying to argue against pre-invocation. With all due respect to those who make those arguments, I don't really think they hold water. There's nothing in the text of the Constitution or Section 33 in particular that indicates that preemptive invocation is illegitimate. So for better or for worse, legislatures do not need to wait for a court decision to be handed down before they invoke the notwithstanding clause. Whether or not it's justified as a matter of politics or public policy is a very different question altogether. And I'm not prepared to say that there are no cases where it might be justified. I think proponents of Section 33, though, face a challenge in defending preemptive invocations of Section 33 in the abstract or as a regular occurrence. Because as we talked about at the start of this episode, one of the primary justifications given for the inclusion of Section 33 in the Charter is that it provides democratic accountability. It provides a democratic check on the sovereign power that is exercised by courts. And so when we think about it from that perspective, it's often been said that Section 33 does a couple of things, that it promotes what the late Peter Hogg and co-wrote with Alison Bushell described as legislative judicial dialogue, that it allows the courts to provide an assessment, and Section 33 being a tool that allows the legislature to respond. And so this helps promote greater transparency and inter-institutional dialogue between courts and legislatures. And so kind of coming out of that whole quote unquote dialogue theory, one of the defenses of Section 33 that's been given is that it promotes what's called coordinate interpretation of the Charter. It allows different institutions to put forward different interpretations of the Constitution and its provisions. I'll say that the whole coordinate interpretation argument, I don't fully buy it, with no disrespect to those who make that argument, just simply because, as we've noted, there is nothing in Section 33 that requires a legislature to actually put forward any kind of legal interpretation or interpretation of the Constitution. Strictly speaking, the legislature can invoke Section 33 for whatever reason it wants. But when we think about this in the case of preemptive invocation, it does strike me that preemptive invocation can undercut those arguments a bit somewhat. If the whole idea here is that we are ensuring that both institutions, courts and legislatures, are able to put forward interpretations of the Constitution and to respond in kind, well, preemptive invocation cuts off that dialogue. It doesn't become a dialogue at all. If you buy the argument that declaratory relief is not available, it would simply mean that the legislature has spoken, and there's really nothing the courts can do to strike down a law on the basis of Sections 2 or 7 through 15, as long as Section 33 remains invoked. So I think on that basis, it's harder to justify preemptive invocations, though an argument can be made that there are some areas of the law where there is a fairly developed jurisprudence, and there is a fairly consistent line of cases indicating what courts will do. And so the argument has been made, and it's not wholly without merit, that in some cases we may be able to say with pretty significant certainty what the courts are going to do. And so for the sake of preserving judicial resources, preemptive invocation may be justified. But I'll add a caveat to that I'm not convinced that's the case for all sections of the Charter. So perhaps that may be the case for something like Section 12. I would think that it's less so the case for, say, Section 15, for example, where there has been a lot of turmoil in the jurisprudence, and we really have no consistency with regard to the equality rights framework, even almost 40 years on since Section 15 came into effect in 1985. And then beyond that, there are other sections of the Charter which have been subject to more recent interpretation, in Section 2D, for example, where we know that there's been an initial ruling recognizing a particular right, for example, but we haven't really seen it play out how that right is going to be applied, much less how limits on that right are going to be assessed under Section 1. So I think we need to be very, very cautious of pre-invocations, regardless of whether or not they are strictly speaking legal.
As a final question, do you think the political culture surrounding the notwithstanding clause has shifted in recent years? And if so, do you think the clause is still working as it should, at least for the most part?
That's a tricky question to answer. The political culture has unquestionably shifted. Section 33 has very much been thrust into the spotlight. We are seeing open, very vigorous, and at times very polarized debate about Section 33. And I don't think the tenor of the debate has always been constructive, particularly where it's been most polarized. That being said, I don't think the fact that we are having the debate is itself a bad thing. the debate very much was one that was not being had for a long time, and that it was very striking that for the first 30, 35 or so years that we had the charter, that there was this real disconnect between discussions about Section 33 in the realm of political science as opposed to within the legal profession and the legal academy. And to a certain extent, the legal academy adopted a bit more of a monolithic view of Section 33. It tended to be more pessimistic and negative across the board. And so I don't think it's bad that we are seeing rigorous, very serious, good faith defenses of Section 33 that are starting to emerge now, not just in the political science realm, but also within the legal academy. I think just as a matter of intellectual diversity and ensuring that orthodoxies which prevail and which take hold are openly challenged, I think that's a good thing. And I think lawyers and legal scholars shouldn't shy away from that. But I do think that politically, we are seeing a lot of polarization, and we are seeing a lot of assignment of motive. The debate can get particularly nasty at times, regardless of the invocation of Section 33. And there are a whole gamut of different invocations that have arisen in recent years, and they vary widely in terms of what they are responding to, the nature of the rights or freedoms in question, whether they're preemptive, whether they are responding to either an interim or a final ruling. And so I would like to see, on the whole, less polarization around Section 33. That doesn't mean that I want to see the debate end. I want the debate to continue. But what I would like to see is more moderation in that debate and greater efforts at consensus building, and recognizing that this is a particularly difficult issue. It's one that I think certainly you see polarization along ideological lines, but it's also an issue that can divide people within who might otherwise be ideologically fellow travelers. So as an example, I'm the former national director of the Runnymede Society. Runnymede is an intellectually diverse coalition, but as I've said, there's no secret that the median ideological disposition of Runnymede tends to skew right of center. Libertarians, classical liberals, and conservatives very openly belong to Runnymede, and it would be impossible to nail down a consensus in Runnymede on Section 33. You see very strong proponents, those kind of coming more from the conservative, judicially skeptical wing of the movement, but then you see very hard opponents coming more from the libertarian, classically liberal wing of that coalition. And so I would like to see the debate continue in years to come, but I would also like to see that debate really rooted in scholarly rigor and seriousness.
Thank you so much for your time and insights, Kris.
It's my pleasure. Happy to do so anytime.
This brings us to the end of episode 2. As you've heard, the notwithstanding clause is just as complex in practice as it is in theory. And as governments like Ontario begin to experiment with it more, making sense of it becomes more pressing. Whether governments should hold the power to avoid judicial oversight via Section 33 is clearly debatable, and this conversation gets more interesting when you look to Quebec, which has had a unique relationship with Section 33 since its inception. We'll talk about this relationship and Quebec's recent use of Section 33 for its controversial secularism law in the next episode. Thanks for listening.